All right. Clarence Morgan. 21 CRB 00756. This is from August 22nd, 2021, a domestic violence charge. Counsel, good morning.
How are you, Your Honor?
Excellent.
Alan Goodman. We were 12660. Mr. Morgan was here. I worked out, I believe, the resolution of this case with Prosecutor McCullough. I just left.
Ms. McCullough? Thank you, counsel. So I do see that you worked out a resolution, and I'm going to hear from our prosecutor. It looks like the domestic violence is being amended to a charge of disorderly conduct. Okay, counsel?
The victim, Gloria Morgan, is present today. She just opened the door now.
Okay, thank you.
We had a discussion this morning. She said some good things about her husband and their relationship. She said that most of this was born out of an argument, born out of their decision to get divorced, and so things are starting to become contentious as they move towards that. So in light of their past history, she wanted to reduce the charge to disorderly conduct. She would like to have the restraining order lifted because they are going to have discussions about settling the dissolution of their marriage. But I do recommend that you still get that police escort when he's removing the remainder of his things. Then there's some issue about the dog, but Miss Morgan is present, so she can address some of those matters.
Okay. Ms. Morgan, is that correct? That's your desire at this time to have this case? You're okay with the reduction from domestic violence to disorderly conduct? Okay. And the reason that's important, counsel, is because normally I don't do that anymore in this court. If it's a domestic violence, we stick with it through the end. Either you're not guilty or you're guilty. But when there's a situation that the prosecutor has spoken with the victim in this matter and they believe that this is the best way to resolve a case, I'm open to it. And it seems like that's what we're dealing with here. I do want to let you know, though, Mr. Morgan, even with a reduction to disorderly conduct, that's still a first-degree misdemeanor in East Cleveland, which means you could get up to a $1,000 fine and 6 months in jail, and you could very likely get probation. So I want you to understand the benefit that your attorney is working out for you is that you won't have a domestic violence on your record, which is an escalating event, meaning the next time you're charged, it's a felony. So you understand all that? All right, so I'm going to get the plea. I'm going to get a dissertation of the facts, or at least the factual basis, and then I'll hear from the defendant. So, to the charge of disorderly conduct, counsel, the plea?
We would enter a no contest plea.
Okay. Madam Prosecutor.
To the written statement that was written by Ms. Morgan, she states that she was home asleep and Mr. Morgan came in and requested the keys to her truck. She asked him to leave, and then he said that he was going to make a video of her assaulting him, that she had attacked him, and he was going to make this video. And then she stated that she was going to call the police because things were escalating. And he said fine because he already had this video, but then he hit her. So yeah, that was the basics of what happened. It goes on about some things that had happened a couple of weeks prior, but that wasn't part of this particular charge. So most of this was an argument, and I guess.
Okay. All right, so based on that information, I will go ahead and enter the finding of guilt. It'll be 180 days in jail, suspending the jail time, giving you credit for the 5 days that you were downstairs. It'll be a $300 fine plus costs. But here's what I'm doing interestingly, and Mr. Medley, if you can listen to this, this is important. So I am going to impose a term of probation, and I'm going to start it at 12 months. But what I'm doing is I'm doing this while the proceedings are going on. So basically, what's happening is your jail time is suspended, meaning you're not going to go to jail, but the probation requirement is that you two make it through these proceedings that you're going through without any incident. And once you're done with that, and I do 12 months here because that could take a little bit longer. Once we're satisfied that that's been done, then we'll reconsider what happens on probation. If there's something else that goes on, we may have to change the terms at that point. Ms. Johnson?
Samara Johnson is the delegate for the record. I just wanted to state that during the inquiring the information about this case, there was some suspected drinking, believe that Mr. Morgan may have a drinking problem. So we would like the court to address that as well, please.
Okay, so whatever happens, counsel, whenever that's brought up, what I do at the very least is a drug and alcohol assessment. And, you know, it doesn't mean that you can't have a drink, but if it's determined that there's an issue that we need to address, then that's something that we will address to help you with. Because, you know, even going through this proceeding will be stressful. So we want to put you in a position where you're winning and you're not ending up in jail, you know, based on losing control in any way. Counsel?
Is this is active probation?
So technically, I'm going to put here, after the drug and alcohol assessment, it will be inactive, monitoring whatever happens with the assessment and monitoring the divorce proceedings. So I'm starting off with the assessment, but I'm starting off, as long as that goes well, it's an inactive probation, because I want you two to work through this other situation, without any added stress. Once that's complete, probation will bring them back before me. We'll see how everything was going. And at that point, counsel, I may say, well, now I want some anger management, or maybe I'll say we're done. It all depends on how we're traveling through this divorce. All right. Everyone on the same page? All right. The date for the meeting, Bailiff Sanders? So it'll be September 8th at 9 o'clock to go and set everything up with probation.
I don't have.
Correct. Counsel does not have to be here.
Okay.
And Madam Prosecutor, is there anything else that I need to know for the record in regard to the TPO? We are asking that to be lifted, correct?
Correct.
All right. So I will go ahead and lift the TPO at this time.
And the police will help him get his stuff out at good time.
Thank you. And that's what we spoke about prior to.
Oh, there's also, the police have his phone, not to like red light.
Yeah, so there's no reason for them to have your phone. So I'll put here that any personal items shall be returned.
Okay.
Any other issues or any other things we need to discuss?
Again, the personal items are, okay, well,
Yeah, I'm going to put it in the journal here.
what?
I'm going to put here in the journal that personal items shall be returned if the police have them.
All right. Thank
All right.
you.
You're welcome. All right. If there's nothing else, you just step right down here. Mr. Morgan, counsel, we'll see you later. Take care. 9 o'clock on September 8th. All right.
You know that's true, right?
Inzisha Banks. Ms. Banks, 13 TRD 01150. This is from April 11th, a driving under suspension. And then we have 14 TRD 00090 from January 12th of 2014, a driving under suspension, license plate obstructed and seatbelt. So Ms. Banks, I'll use this opportunity. I'm not sure if I mentioned it, but it's important. So what happens with driving under suspension in Cuyahoga County, because it's been happening so much, the fines have gotten pretty high. They range anywhere between $500 to $1,000. I've never given a $1,000 fine, but I've seen that come back from other courts. Points on your license can be suspended for an additional period of time, and then there was a time when judges were putting people in jail for driving under suspension. In East Cleveland, the way we handle it is that we put you in a position where you're not going to get any points if everything is okay with the prosecutor in that regard. I don't resuspend your license. I don't put people in jail for driving under suspension. And if you get your license in a better position, I cut your fines in half, even from the minimum. So that's with anyone that's dealing with a driving under suspension. So what I have in front of me is what it looks like is an agreement where the city prosecutor was going to dismiss the entire case from 2014, and you were going to enter a plea to one charge in 2013 case of failing to display your license, which means we amended it from driving under suspension and lowered it to failing to display. Is that your understanding? All right, to that charge, how do you plead? All right, so with all that being said, as I mentioned, your fine is going to be cut in half as opposed to $500. It'll be $250 plus costs. Everything else will be dismissed in that second charge. And then what happens with your bond, as long as your bond is still valid. So for instance, some people post a bond, let's say in 2012, they never come back to court. That bond is probably forfeited. But if you posted a bond to get this court date, that bond does not disappear. So when you go to the clerk's office, they'll do the calculation. If we owe you money, they'll tell you how you get it. If you owe us some additional money, we'll give you time to pay it. All right. So once you go to the clerk's office, they'll do the calculation with any bond that you posted as opposed to your fines and costs. You understand that? All right. So you're free to go. Take care. Nico Russell, I'm sorry. Mr. Russell, 21 TRD 03439 from June 22nd, of driving under suspension and speeding. Looks like the city is amending your charge. Your license must be in a better position. So you're able to get the lower charge, and they also are agreeing to dismiss the speeding. Is that your understanding? All right. So to that amended charge, how do you plead? All right. So as I mentioned, as opposed to the minimum fine, which is $500, I'm going to cut that all the way in half to $250. The moving violation, the speeding will be dismissed, so you're not going to get a fine or any points in that regard. We have your insurance, so if you need time to pay, we'll give you the details at the clerk's office, okay? Any questions, sir? All right, you're free to go. Take care. Is it Demisha or Demacia? Damacia, come on up. I'm sorry about that. Damacia, okay. Damacia, thank you very much. Burkhalter? Yes. All right. This is 16 TRD 02393 from July 14th, alleging no driver's license, failing to maintain full time and attention, and failure to control your vehicle. At this point, the charge is being amended to failing to display, which keeps you from getting any points. Is that your understanding? Mm-hmm. Now, what's going on with your insurance? Do you have insurance?
Yes, I do.
You have it now, or you're going to show it in 72 hours?
I can show it in 72 hours.
Okay, so I'll put that here. Just make sure you make it back to the clerk's office. That way you don't get suspended.
Okay.
And it looks like the agreement is to have you plead to that charge and dismiss the remaining. So how do you plead? Is it no contest?
Yeah.
All right. So Ms. Ballcarter, you missed a lot of court. What was going on?
Well, I had 2 passings around that time and 3 passings recently. So
Okay.
I had to reschedule, and it's just been a lot going on.
All right. So what I'm going to do in your position, the reason I even asked you that. So first of all, the minimum fine is $500. I'm going to cut it in half to $250, right?
Okay.
But then I see that you've missed court so many times that you've lost money. Like your bonds have been forfeited
Yeah.
before. So I'm going to give you a little bit deeper break here, because it's really not about money. It's more about you getting your license together and coming to court when you're supposed to. That you got to do that. But I understand things happen. So bottom line, what I'm going to do, as opposed to the $250 fine in your particular case, I'm going to suspend $200 of that. So you'll owe us $50 plus costs. You just go to the clerk's office. All right.
Okay.
Take care. Be blessed. Joseph Carty.
Dixon?
Mr. Carty, good afternoon or good morning. All right, so what I have here is 21 TRC 104, and then also 21 CRB 00789. The CRB is a criminal case, right, where you're looking at the possibility of a $1,000 fine and 6 months in jail, because they're saying that you consumed alcohol in your motor vehicle on August 30th, right? So you understand that charge? You understand that charge? All right. And then the other charge, the other case is dealing with an OVI charge, saying that you're driving without a valid license, failed to control your vehicle, and then also had unlawful or expired plates. And you spoke with the defense attorney, Mr. Humphrey, correct? Yes, all right. So it looks like what he's done is maintain not guilty for you at this time, which will have us setting a pretrial for you, a day to come back, which will be September 20th at 9:30, okay? Now, a couple things before I'm gonna give you that date, September 20th, 9:30. But keep in mind, what they're claiming is your license were expired. Hold on one second. So, Ms. McCullough, I haven't seen this lately. The 2255 form. It doesn't state that the driver refused.
I noticed that myself.
Okay,
I was
so-
looking at it,
So, Mr. Carty, the reason I'm looking at this, from what I see here, now, just take this with caution. Normally, there is a way for you to have an OVI charge and your license are immediately suspended based on what happens between you and the officers. Or you understand that? I don't see that here. They didn't mark the particular boxes that I normally see that would indicate to me that your license are suspended now. So I don't see that. However, when we get your case resolved, normally with OVIs, if there is a conviction, you will have a license suspension. The minimum fine, according to the Ohio Revised Code, is $375 with a maximum fine of $1,075. If this is your first OVI in 10 years, you're looking at a minimum of 3 days. You could get a 3-day class. The maximum jail time I can give you is 6 months. If this is not your first one in 10 years, the fine goes up as well as your possible jail time. So you understand all that? All right. So again, right now we're maintaining not guilty, and I will see you back on September 20th. Are there any questions that you have? All right, we'll see you back then, sir. Jermaine Smith. Mr. Smith, 21 TRC 04074. Good morning. Mr. Smith, this is an OVI charge. They marked that you did have insurance. They marked that you submitted to a test. You recall that, correct? But what's noted here is what you blew. Well, what I see here, unless there's something that changes, because I know you're entering a plea of not guilty today. What I see here is that you blew a .02, right? You understand that? Well, no, do you understand the words I just said, though? That's what they put here, that you blew that. Okay, not saying that you agreed to it or anything. They're saying that you blew a .02. So we're going to talk about that when you come back. It's, unless there's something different here, just generally speaking, the limit is .08. So in regard to the test, it looks like you may be below the test. But again, based on other circumstances, it looks like that's why the charge is being presented. They did mark some other things as far as smell of alcohol and glossy eyes. However, your attorney is maintaining not guilty at this point on all those charges. So what I'm going to do, Mr. Smith, out of fairness to you, based on what I have here, because they marked something about you blowing and it was submitted to the BMV, I don't want there to be any mistake in regard to a suspension. I don't see where you would be suspended based on what you blew. So what I'm going to put in my journal entry that any suspension at this point, as of today, is stayed, right? If you resolve this case with a conviction, I will impose a suspension, but then I can give you privileges and all that stuff. But as far as an automatic suspension based on your stop, I'm going to stay that right now. So you are okay with driving right now, but you may want to get a copy of my entry in that regard, all right? So I'll see you back on any objection to that, Madam Prosecutor? You understand why I'm doing that? Okay. All right. September 23rd at 9:30. Go ahead. They have your ID? What'd you say about your ID? Yeah, so as far as your your ID, one of the things, I guess at this point, we have to wait until the case is resolved. I don't have your ID. There were,
Wallet, I mean, maybe in the wallet, you saying you didn't get the wallet.
you didn't get your wallet back either. So as far as your personal items like that, there's no reason for them to still have your personal items. So you can make a request. I can put in the journal entry that your personal items shall be returned. If it was an issue of your ID, many times or back in the day, they would put that in the file with me and I could even hand it over to you. They don't do that anymore. Oftentimes, if you blow over the limit or something like that, it's sent to the BMV. So it could actually be out of the possession of anyone in East Cleveland. But it sounds to me that it may be in your wallet. So I'm going to put in this journal entry that your personal items shall be returned to you because I don't see any reason based on what you're charged with for them to have them. All right. So you're going to want to get a copy of this. One of my bailiffs can provide that for you. But keep in mind, as I mentioned before, the OVIs in Ohio are very serious, which is why those penalties of the jail time continue to escalate, and the fact that you cannot get a second, third, or whatever OVI within 10 years. It used to be a shorter period of time, but the Ohio Revised Code and the legislature are so serious about it that they made it even longer. So don't take it lightly that you should not be drinking and driving. You want to be very careful in that regard, all right? So as of right now, it's not guilty. I'm going to put some stuff in the journal entry. You may want to get a copy of that, and I'll see you back on your pretrial date. Take care. Kimberly Carnegie. Come on up. 20 CRB 00885 is a charge of assault from October 12th of last year, 2020. And in that particular case, they were alleging that you did cause physical harm to a Ramona Manuel. Specifically, they're saying that you shot this person with a paint gun at least 9 times while you were riding on a motor vehicle. So that's the assault charge, a first-degree misdemeanor, up to a $1,000 fine, 6 months in jail. It looks like your attorney, the defense attorney today, is maintaining not guilty. And we're setting that for a pretrial, which will be September 27th at 9:30. And then there's a current charge, 21 TRD 03400, driving under suspension and a sunscreen from June 22nd. And I believe counsel were maintaining not guilty on that one also?
That's correct, Your Honor. This is Ms. Carnegie, correct?
Yes.
Your Honor, additionally, we've asked that if East Cleveland has any warrant blocks, that those be lifted. She's attempting to get her license straightened out, and we would ask for, if possible, a pretrial. She said it would take at least 30 days, but she's diligently working. She was actually up at East Cleveland Court trying to get warrant blocks lifted and get her license straightened out when they informed her about that case from last year.
Okay. So can we do an October date? Because you didn't give it to her yet. We may change that date. We'll move that to October 4th. I can write it on there. He write it, it's gonna look like October 4th at 9:30. So I'm gonna give you that additional time, all right? So basically what's happening is we're maintaining not guilty on both the DUS charge and the assault charge. Now, keep in mind, the reason you probably have those blocks is because you didn't come to court on the assault charge. Maybe you didn't know about it. Yeah, the way it's written, I can tell maybe you didn't know. Okay. So with me lifting your blocks, basically you're promising me between you and I that you're going to make it back to court because I'm not holding anything over you. So come back to court. I'm going to put in the journal entry that your blocks shall be released. So before you leave the building, get a copy of the releases. All right?
Okay.
All right. We'll see you soon. You're welcome. Yeah, just go to the clerk's office. Once they get the file, that's when they'll do this work for you. All right.
Blakely?
How you doing, sir? Counsel, good morning.
Complete not guilty. What's going on with your license?
Edith Watkins. Ms. Watkins, I have 18 CRB 00853. Good morning. That was from August 20th of 2018, alleging a disorderly conduct. They were saying that you were yelling and swearing in the Coventry Road area at that time. It looks like through your attorney, we are maintaining not guilty on that particular charge. And we're going to reset your court date for September 30th at 9:30 so that the attorneys can see how we're going to get the case resolved. And then there's a new case dealing with your driving, saying that your licenses are not valid right now in 21 TRD 03770. And there was a traffic control device that maybe you didn't stop at or you disregarded in some form. We're maintaining not guilty on that one also. So you're going to try and get your license together by the 30th? Okay, so you know what you need to do. All right, so we're maintaining not guilty on all of those, and I'll see you back on September 30th. Take care. Ms. Watkins, if you need a block lifted, I'm going to do that in the 18 case. You can go to the clerk's office. They may have lifted your block. Do you have any blocks from East Cleveland that you know of? Okay. So I'm going to put here that if we were blocking your license, because normally we would, because your case is so old, that if you go to the clerk's office, that they'll lift that for you and give you a release form so you can work toward, so you can work toward getting your license. You're welcome. So once they get the file out there, they'll call you up, okay? All right, take care. You're welcome. Kiara Adams. 21 CRB 00777. This is from August 20th of this year, alleging that there was a child endangerment event. Okay. The complaint is specifically stating that on or about August 20th of this year, there was a substantial risk to a juvenile child by violating the duty of care or protection by leaving the infant in a residence alone. And they put here an attempt to keep your boyfriend from taking your vehicle. Counsel, you spoke with Miss Adams?
I did, Your Honor. Prior to even entering a not guilty plea, we'd ask the court to rule on the motion to dismiss. The complaint is defective on its face in that in the to-wit statement it alleges conduct by another individual, not my client. I did show the prosecutor and inform her that I was requesting that the court dismiss this without prejudice. That would allow the city, if they so chose, to correct the indictment and refile proper charges.
Madam Prosecutor, in response?
I won't object to that. I know that this has happened before. The police department is utilizing a new system, and for some reason, sometimes when they're inputting information and drawing up complaints, it sometimes reverts to other matters and puts that into it rather than the current. I'm not sure what the glitch is, but it's happened before. And just based on what I'm understanding this charge might be, we may not even refile it. So I have no objection to it being dismissed, and I'll look into it further.
Miss Adams, how old are you? 26? Okay. All right, so at this point, Miss Adams, you don't have to say anything at all. Just hear me out for a moment. In this particular charge, you could have gotten up to a $1,000 fine and 6 months in jail. Your attorney, the defense attorney, the public defender, by way of oral testimony and in support of this motion that is supplied here, is asking the court to dismiss the complaint based on the fact that it alleges the conduct of a Landon Coleman as opposed to Kiera Adams. So they have a defect in the name. The prosecutor has an opportunity to object to that or motion the court to do other things. At this point, there is no objection. So with those two parties presenting that to me, I don't have a problem at this point disposing of the case, but two things to keep in mind, even the attorney mentioned, if the city felt or wanted to try to rebring these charges for whatever reason, because of maybe the facts exist, that could happen. So be aware of that so that there's no warrant for your arrest. But most importantly, Miss Adams, just based on what I read there, you have to be very careful. And if this case is dismissed and if there's no recharging, and if these things occurred, you dodged a major bullet. So just be really careful. I know it's probably hard to manage, relationships and a child and all that stuff and determining what to do, but you got to make sure you keep your child's safety as your primary, objective. And if someone, even your boyfriend, if he's taking your car or something like that, you call 911 and get him arrested. Okay. Yeah, but I wouldn't want, but be careful, because you can understand the risk of leaving an infant, even for a moment. They're just so busy and anything can happen. So that's why the charges exist. But right now, based on everything presented to me, I will go ahead and dismiss it at this point, all right? All right, you're free to go. Karan Wynn Jr. Mr. Wynn, these are two charges. We have a felony charge, correct? Or this was reduced?
Correct.
All right. All right, so Mr. Wynn, I do recall now, you were before me on these felony charges of improper transportation of a firearm in a motor vehicle and a CCW. The charges were reduced to a misdemeanor of the first degree of a CCW, and then you were going to work with our probation department and be placed in the cycle breaker program that I have here. You remember all that? The overall goal of the program is that you are placed on probation. There are several things that the court is going to ask you to do. Probation will monitor that. You do those things successfully and you come back before me and the case is dismissed. And the reason that's being done is because obviously the impression that city detectives and the court has is that you are in a position where this can be a mistake that doesn't have to define your entire life. So we give you the opportunity to work it off your record before it even gets on your record. So you won't even have to necessarily file for an expungement because it can be dismissed if you complete the program. But let's start with a plea where it looks like you are going to plead no contest to the charges, correct? All right, so I have to hear it from you. So I'll accept the plea, and then what I do is I hold the finding in abeyance, which means I'm not finding you guilty right now. There'll be a 6-month minimum term of probation. The reason I give you 6 months as a minimum term, that gives you a chance to complete the program. But if you don't complete the program that I give to you, you can be kicked off the program, which means you'll have this on your record, or probation can be extended, things like that. So it gives you a little bit of time. So the initial requirement of the program is for you, Mr. Medley, you have the printouts, right? Of these, what he has to do? No, for the how to get to the cycle breaker videos and us. You have that? Okay, cool. Oh, you have the gold sheet too?
Yes.
Good, because I don't have any up here.
Nice, little small ones.
Well, you know what? I have the bigger ones, but I may give it to him. All right, so here's the deal. The initial part of the program is that you have to attend 12 sessions of the Finish First program. Now, with COVID-19 and all of those things that we've been dealing with, your attendance is actually online. So you don't have to step foot in the court to attend them. The videos are either through the website that probation will give you or just simply on my YouTube page, Judge Dawson, right? And at this point, because we've been doing this through the whole pandemic, there are 60 videos or more. You're required to watch 12 of them. And basically what happens is every Monday on the website, there'll be a link that you can click that will lead you right to the video of the week, right? You watch the video and you answer the questions at the end. And this is very important. Then you send those to your probation department. That's your attendance, because we've been running into problems where people either are sending them to the wrong email address or not doing the work at all. And if you don't do the work, you didn't attend. So don't mess that up, because this is a great opportunity for you. That's one. Second thing, Mr. Medley is going to give you a packet that we have dealing with guns. You complete that. Again, you can do all this on your own time because you have time to do it. You complete that. That's the second one. And then the last thing I'm going to have you do is I'm going to give this to you now, because Mr. Medley, you may not have them on you right now. So this little worksheet, I have 6 boxes, and I'm asking you prior to meeting with probation to tell me what your goals are for the next 5 years, financially, business, educationally, family, spiritual, fitness, all that stuff. So this is what you're going to take to probation when you have your first meeting. Any questions about any of that? No. All right. A date, Bailiff Sanders? I got one more thing to tell you. So September 8th at 10 o'clock. Now, the last thing, there's a fee for the program, which covers the expungement and all those other items. It's $425, but you have the entire 6 months to take care of that. If you can't do it now, you don't have to, but make a payment plan and something like that. But once you complete probation, you come back before me, and then the case is dismissed. That's the goal. Any questions?
No, but I still ain't received my phone or my house keys.
Did I put in your journal that they were supposed to give you that stuff back? Or did I do that, counsel? I don't see anything.
I don't recall.
Okay.
We'll consent to the forfeiture of the weapon and ask that all other property be released.
All right. So I'm going to put in here that your personal property, other than the weapon, because that's the agreement, shall be returned to you. So you may want to get a copy of what I'm writing here, take it to the police department. They should give you your stuff back. Okay. All right. But right now, you just step right down there. Thanks.
I apologize for being honest. Was that 10 o'clock?
It is 10 o'clock on the 8th. Yep. Come on up.
We have a case that I have strategically waited to the end because you were not even going to entertain it in a courtroom full of people. So I wanted to talk to you about it, but it's probably best after everybody's done.
Okay.
Explain the specific reasons as to how we arrived here. It's an OVI charge where he blew a .8. We charged him with a red light OVI and not having his headlights on. I talked to him, I talked to the prosecutor and read the report. I mean, I know .08 OVI, what happened, he openly admits to running a red light. Police came up to the car and were demanding his driver's license. He's in his work truck, he works. He's like, I'm not reaching behind my seat. Which on some things, he's like, I'm valid, I've got insurance, and I'm not comfortable reaching behind my seat. Yanked him out of the car, pulled tasers out, searched his car, found his, he was valid. But things escalated to the point where they're like, oh, you smell like alcohol. He's like, well, I got at it last night, took him, it's .8.
Okay.
So, I have negotiated a red light in an open container. There's open containers in the work truck, but.
And you're okay with that?
Yeah, I've had experience with him before. He hasn't really been a problem. We've had like .08s, and I think, to be honest with you, there's so much going on right now. Everybody seems to be on edge, and so it's not taking a lot for people to
Okay.
push things.
So I'm cool with that. Now, the only other thing, just because, I don't know, we'll clear the courtroom, and I'm not sure how much you two will agree to what you want to put on the record. I can accept your plea because you're aware of that.
Yes, I've noticed.
I just put that. Not only that, hold on to me. So Zach. So in addition to everyone else that's around, that's there. So, you know, it can be political. I don't know what you, I'm not saying what you should do or not do.
I don't know why.
Contest, but I'm waive reading the facts.
There we go.
Good.
All right. Thank you. All right. Sean Carmichael? Yes. Did I drop some? Thank you. I couldn't see your hand, but I figured it out quick. Mr. Carmichael, this is 19 TRD 01753, driving under suspension and a no driver's license from May 5th of 2019. It's being amended to that failing to display, which gives you a lower fine, no points, no suspension. The only thing is they marked no for insurance. Are you going to be able to come back with insurance? You have it now?